The room went silent before anyone said a word, not the normal courtroom quiet, the polite kind that fades in and out between cases, but a sudden, unnatural stillness, the kind that happens when something crosses a line everyone can feel, even if no one has named it yet. The senator didn't raise his voice. He didn't need to. "I can have you removed from this bench." He said it calmly, measured, almost casual, and somehow that made it worse, because threats are easy to dismiss when they come with anger. But this wasn't anger, this was certainty. I remember the exact time. 9:42 a.m., the second case on the docket. A routine traffic violation involving a young man named Daniel Reeves, 23 years old. No prior record. A minor offense that should have taken 5 minutes. Instead, it became something else entirely. Because Daniel Reeves wasn't just another defendant. He was the son of State Senator Victor Reeves. And Victor Reeves had just stepped into my courtroom uninvited and made a mistake he didn't yet understand. What happened next didn't just decide a case, it exposed something much bigger. And once it started, there was no stopping it. Let me explain something. A courtroom runs on structure, order, sequence. It is one of the last places where process still matters more than personality. At least that is the intention. Cases are called, facts are presented, decisions are made. No interruptions, no interference, that's the design. But every so often, someone walks in believing that design does not apply to them. That morning, Senator Reeves walked in with that belief, and he carried it like armor. His son stood at the defense table, nervous, shoulders slightly tense, eyes moving too quickly. That told me everything I needed to know. This was not someone used to being in trouble. This was someone used to being protected from it. I began the case the way I always do. "Mr. Reeves, do you understand the charge against you?" Before the young man could answer, his father spoke. "He understands enough," the senator said, stepping forward. There was a shift in the room, small but noticeable, because that was the first break in protocol. And once protocol breaks, things can unravel quickly. I looked at him. "Sir, are you representing your son as counsel?" "No," he said. "I'm ensuring this is handled correctly." There it was, the language of influence, not loud, not aggressive, just implied authority. If you appreciate stories where power finally meets consequences, stay with me, because this is where everything begins to turn. I've seen this before, not often, but enough times to recognize the pattern. A person of influence enters a space built on rules and tests whether those rules will hold. Sometimes they do, sometimes they don't. That morning, they did, but not immediately, because the senator wasn't finished. "You need to understand something," he said, his tone tightening slightly. "This situation doesn't need to be complicated." I leaned back, not reacting, not escalating, just observing. "Then it won't be," I said, "if we follow the process." Another pause, longer this time, because now we were no longer talking about a traffic violation. We were talking about control. The charge itself was simple: reckless driving, clocked at 47 in a 25 zone on Maple Street at 11:18 p.m. Body cam footage, radar confirmation, officer testimony, clear, undeniable. The kind of case that usually resolves quickly, but this wasn't moving quickly anymore, because every time I tried to proceed, the senator interrupted. Subtle at first, a comment here, a question there, then more direct. "Is that really necessary? Do we need to go through all of this? Let's not waste time." Each statement small on its own, but together they formed pressure. And pressure, when applied consistently, is designed to do one thing: change outcomes. At 9:51 a.m., I stopped the proceedings, completely. I looked directly at Senator Reeves, and I said, "Sir, this is your final warning. You are not part of this case." That was the moment everything shifted, because instead of stepping back, he stepped forward. "I don't think you understand the position you're in," he said. His voice dropped, lower, sharper. "I have the authority to make changes that affect people in your position." There it was. Clear. No longer implied, not a suggestion, a statement. And for a brief moment, the entire courtroom held its breath. Because everyone knew exactly what had just happened. This was no longer influence. This was intimidation. Now here is the part most people don't realize. Authority is tested in moments like this, not when things are easy, not when everyone agrees, but when pressure is applied and something has to give. Usually, it's the system, but not that day. I didn't respond immediately, not because I didn't have an answer, but because moments like this deserve precision. If you rush, you lose control, and control was exactly what needed to be maintained. At 9:53 a.m., I leaned forward, and I said something very simple. You may have authority in your world. Pause. But in this courtroom, the law is the only authority that matters. Silence, complete, total. Not even the shuffle of papers. Because that sentence did something important. It redefined the room. The senator didn't speak, not right away, and that hesitation was the first sign something had changed. Because power, when it meets something it cannot override, pauses. But here's where the story becomes bigger. Because what happened next wasn't about words, it was about evidence. At 9:55 a.m., I requested the full incident report, not just the summary, everything. Body cam footage, officer logs, dispatch records, standard procedure, but in this case, necessary, because something wasn't adding up, not legally, behaviorally. The officer stepped forward. Officer Daniel Ortiz, 5 years on the force, clean record, consistent reporting. I asked him one question. Was there anything unusual about this stop? He hesitated, just slightly. Yes, Your Honor. That was the moment. The one that changes everything. Because hesitation from a trained officer means there's more. Explain. He made a call, the officer said, immediately after being stopped. To who? He didn't say, but within 3 minutes, I received a call from dispatch. And what did dispatch say? The officer shifted slightly. They said to proceed carefully. Carefully. That word doesn't belong in routine traffic stops, not like that. And then? I asked. Within 10 minutes, another vehicle arrived. What kind of vehicle? Unmarked, government plates. The courtroom shifted, you could feel it, because now this wasn't a traffic case anymore. And who exited the vehicle? The officer glanced briefly at the senator, then back at me. He did. There it was, the center of gravity, the moment everything changed. Because now we weren't dealing with a father showing up in court. We were dealing with a father intervening at the scene. What happened when he arrived? I asked. The officer took a breath. He instructed me to release his son. And did you? No, Your Honor. Why not? Because the violation had already been recorded. That answer mattered. A lot. Because it established something critical. Resistance. The system had not bent. And what happened next? Another pause. He said there would be consequences. The courtroom went completely still. Again, but this time heavier. Because now we had a pattern. Not a moment. A pattern. I looked at Senator Reeves. For the first time, truly looked. And I saw something different. Not confidence, calculation. If you believe no one is above accountability, I said quietly, pay attention to what happens next. Because now, this wasn't just a courtroom exchange. This was documentation. I turned back to the officer. Did you document that interaction? Yes, Your Honor. Is it included in your report? Yes. And the body cam? It recorded everything. That was it. Proof. Not interpretation, not opinion. Record. At 10:02 a.m., the courtroom dynamic collapsed. Not loudly, not dramatically, just definitively. Because once evidence enters the room, power leaves. I turned to the senator. Would you like to revise your earlier statement? He didn't answer, because there was nothing left to say. The case against his son proceeded, standard, measured, appropriate. No special treatment, no additional punishment, just equal application of the law. But the real consequence wasn't happening at the defense table. It was happening somewhere else. Because what had just been revealed didn't stay in that room. It couldn't. By 10:15 a.m., the hearing concluded. But the story didn't. Because documentation creates motion, and motion creates outcomes. Within 48 hours, the report was reviewed. Not by me, by oversight, internal, external. Because that is what happens when authority crosses into interference. It gets examined. Within a week, there were questions, formal ones about conduct, about misuse of influence, about attempted obstruction. And the senator, he didn't return to that courtroom, not because he wasn't allowed, but because the room no longer responded to him the way it had before. Power, once exposed, changes. Daniel Reeves paid his fine, completed his requirements, moved on. His case ended where it should have. But his father's actions, they didn't end. They expanded. Because this was never just about a threat, it was about a belief. The belief that authority can override accountability, that some names carry more weight than others, that pressure changes outcomes. That belief was wrong. And the courtroom proved it, not through emotion, not through defiance, but through something far more powerful: structure, evidence, consistency. Because in the end, justice doesn't need to raise its voice, it just needs to stand its ground. At 9:42 a.m., a senator walked into a courtroom believing he could control the outcome. By 10:02 a.m., that belief was gone, not argued away, not negotiated, removed. And that is the difference between power and law. Power demands, law decides. If cases like this remind you why accountability matters, you already understand the lesson. Because the most important thing that happened that morning wasn't what was said, it was what didn't change. The law, still standing, exactly where it was supposed to be.